No. What do you do on your free time? What do you normally do?
Relax. After work, you mean? You have to work.
Relax and drink.
No.
That's why we're here for DWI.
Welcome back. Today we are in a San Antonio courtroom where the judge is already losing her patience. We're starting with a defendant facing his third DWI. That's a felony. Pay attention to how he describes his social drinking, because the judge is about to turn his relaxed lifestyle into a decade of legal headaches. Let's jump in.
It's honest. What you call a social drinker when you special.
So you just drink to intoxication.
You don't say that, that's fine. That's
Well, I mean, no, this is
yeah, I'm just telling you, I go to
all right. So you're Mr. Ruiz, you're looking at me very quizzical. Do you understand what's happening here? All right, just for a moment. If this witness is going to deny what she's told the police, she'll probably need to have an attorney appointed to represent her. Your attorney doesn't want to date you.
Wait, did you catch that? The judge just had to remind the defendant that his attorney isn't his date. But more importantly, look at the transition at 033. The prosecutor is warning the witness that if she changes her story from what she told the police, she'll need her own lawyer. That's a polite way of saying, if you lie now, protect him. You're going down for perjury. The stakes just doubled.
No, listen to me. Your attorney doesn't want to date you. And I'm going to appoint you a male attorney. If you want to say, hey, sexy baby to them, just see how that goes. In prison and up to a $10,000 fine. Did you understand? If after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would just pray that the court follow the plea agreement. We would also ask the court to give consideration to his indigent status and needing to work. He knows that he'll need to obtain an occupational license and would need permission from the court to move around from that perspective. His driver's license has been suspended for 80 days. It's caused him some issues, but he has not been driving at all. So we would ask the court to give some consideration on the driver's license suspension length.
All right. What do you do for work?
construction, concrete.
And how old are you, sir?
I'm
How old are you?
59, gonna be 59 June.
Oh, okay. Well, happy birthday upcoming.
10 years in prison, suspended. In plain English, he's on the thinnest ice possible. If he so much as smells a beer or misses a Zoom check-in, that 10-year suspended sentence turns into 10 years behind bars. The judge is offering a lifeline, but with 200 hours of community service and random drug tests, the party is officially over. Do you think 20 days of GPS monitoring is enough for a third-time offender? Drop a comment below.
Thank you.
All right. This is what the court is going to do. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. I'm going to want a referral to felony drug court and also a TAP evaluation out of custody. Does he want to do 10 days at the Bexar County Jail or 10 days on GPS?
GPS one.
All right, there should be, I'm sorry, not 10 days on GPS. It would be 20 because if he wants it partial. If he doesn't want a partial, then he have to do 10 days full house arrest.
Can I have 10 seconds?
Sure.
Your Honor, if I can, just to verify for the record. So you understand the 10 days, the court would allow you to do 10 days of GPS at home, you would not be able to work. It's full house arrest. That's what she meant by partial. So the 20 days, you would be able to get permission from probation officers approved by the court for work purposes. And it will be for the GPS, for you to have the GPS, and that will be in lieu of you being taken into custody for an additional 10 days. So those are the options. So I believe, Judge, we'd like to do the 20.
20.
Okay. All right, there's to be 20 days of GPS, partial for employment.
And if to bring to the court's attention, he's already on GPS. So just so the court knows, I don't know if the court can or would give him credit for the time he's been on GPS already anyway.
There's going to be field visits 1 time per month for 6 months. 200 hours of community service restitution. What do you do in your free time?
Well, I guess I'm gonna be doing that.
Yeah. What do you do on your free time? What do you normally do?
Relax. After
No.
work, you mean? That's what I do after work.
Relax and drink.
No.
That's why we're here for DWIs.
It's on a special occasion, that's it. You know, it's
What was
not-
your-
It's not an everyday thing.
What was your special occasion on this day?
Party, like
Huh?
Halloween party.
All right. And what was your special occasion for the other two DWIs?
Just festivals.
Mm-hmm.
That's how we look at it.
Yeah, so
I'm not a drinker every day. I'm sorry, I'm not. I'm seriously, I'm not. What you call a social drinker when it's special.
So you just drink to intoxication.
You can say that, that's fine. That's-
Well, I mean, no, this is,
Yeah, I'm just telling you, I go to family functions and we drink and.
And then you
I
drive.
just take out, yes.
all right. So you drink and you drive and you drink to intoxication. Yeah. I mean, and you've done this before. All right. So there's going to be 200 hours community service restitution. Probation. Is there anything else? Yes.
Nothing else. Judge.
Is there anything else you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have questions over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. It appears to the court you have a problem. And you are minimizing your problem. I know a lot of people who celebrate on the holidays and they say, oh, you know, it's a family barbecue or it's 4th of July, we drink, but they don't drink to intoxication and drive. And that's what you continue to do. And you're blaming it on holidays.
I'm not blaming it on knowledge. I'm just saying, ma'am, that's.
And if you drug tested today, what are the results going to be? When's the last time you drank?
All that. I'll come out clean.
You come out. No, when's the last time you drank alcohol?
3 weeks ago.
All right. So see, he still has an alcohol problem.
Ma'am, I'm not been driving, ma'am.
That's good.
No.
Mr.
While you're on
It's
probation,
good.
here's the
But
thing.
probation's a different story.
Here's the thing. While you're on probation, you're not allowed to drink. And anybody, and normally, whether people are telling the truth or not, normally when they pick up a DWI third, you know what their attorney is able to come in and say? My client hasn't had a drink since that night because they were so terrified and knew that they could have killed somebody. You, on the other hand, you're still relaxing, drinking alcohol. That's why I wanted to know what you do in your spare time. I understand people work construction. It's hot. You want to come home? Let me have a beer. But your problem is you want to come home, have a beer, more than one or whatever you're drinking, and then get out and drive. And you can kill somebody. And you're lucky that you did not kill somebody. You understand? And if you don't get it into your mindset that you are one of those people who cannot drink and drive, you're going to end up picking up another DWI. You're going to end up killing somebody. And then you're going to come in here crying and still come before a judge and say, oh, I drank about 3 weeks ago. So you had better change yourself. Do you understand?
Yes, ma'am.
I don't understand why people, if you're going to drink, catch the via. You know what you'd have probably been charged with? Public intoxication. Maybe you would have got hit by a car. I don't know why it is here in San Antonio. San Antonio is the only place I know where people are walking on the freeway. I don't know if that has to do with drinking or what, but this is the only city I've seen that happen. Just as a side note, I'm driving on 410. I'm going the speed limit. And guess what? I'm slamming on my brakes. Everything in the back seat is flying forward. You know why? Because somebody has decided to walk on the freeway and crossing 5 lanes of traffic on the freeway.
You know, Judge, I've never thought about it, but you have a point.
Yeah, okay. I could have killed somebody.
Yeah.
And I wasn't drinking. Now, if you would have been driving that, maybe you would have ended up killing them. But good luck to you, sir.
Thank you.
You're welcome.
Baby, excuse your honor.
You may be excused. All right. We have the attorney. All right. Are we here for a bond issue?
I'm gonna ask the court to set a bond on that case and also it's a plea deadline, Your Honor.
All right. Have you conferred with the state on the bond?
Yes, we haven't agreed on an amount, Your Honor.
So the court shows that all discovery was received, and today is your plea deadline date, Mr. Ruiz. So,
We haven't, it's gonna be set for trial, yeah.
all right, so you're, Mr. Ruiz, you're looking at me very quizzical. Do you understand what's happening here? All right, so, the court ordered a plea deadline date for today, which means that the state had tendered an offer. So are you rejecting the state's offer?
No.
Are you requesting a jury trial? All right, state, do you know which case you'll be proceeding on first?
Judge, I only represent him on that 7156, I think.
7154, Judge, and I think
54.
that's, assuming that we have the witnesses, that's the one we've received.
Okay. And who's the attorney on the other matters?
It's Mr. Davidson,
Okay.
Phil Davidson. He only hired court on one case. And Mr. Davidson was appointed.
All right, so with regards to the offer that was extended in the 7154, was that offer to encompass all cases, state?
I would assume so, Judge. It didn't really, oh yes, it did specify take care of all of the cases. So yes, that would encompass all cases.
All right. So, and that cause number, I'm going to need an acknowledgement of discovery. All right, April 3rd is your jury trial date. The court will not accept any plea bargain agreements in this case without good cause. Mr. Ruiz, the court will not accept any plea bargain agreements in this case after today without good cause. Otherwise, you have to plea open to the court. Your jury trial, they're going to bring you over dressed for trial on April 3rd. They will bring you over dressed for trial in whatever clothing you have at the jail. If you wish to be attired in something different, you'll need to sign a clothing exchange for your attorney. Counsel, if there's an issue with the clothing exchange, just let the court know.
Thank you, Judge. And also on the bond, Your Honor, can we have a bond set?
Oh, we can have a hearing on that. And what is the bond currently set at?
I think
It's not without bond, but he had a 40,000 before. I was asked the court if they could just double that one.
All right. So, State, are you ready to proceed on the motion to set bond?
Yes, Your Honor.
Court is calling 2022 CR 7154, State of Texas versus Raymond Ruiz. Can I have parties announced for the record for the state?
Jason Morgan, State State.
Defense?
Nomado Auto representing Mr. Ruiz.
All right, then are you Mr. Ruiz? Defense, you filed a motion to set bond. Do you have any witnesses?
Just, I'm gonna just ask the court to consider the case there, but I can ask the defendant on
I mean,
questions
it's
on the bond.
completely up to both parties if you have witnesses or not.
Yeah,
The
well,
rules of evidence do apply in
don't have any
bond
witnesses.
cases
we're,
where the person is remanded without bond.
Well, I have one witness. I can bring her in right now, Judge.
All right, if you have a witness you would like to call, the court is here to hear witnesses. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please.
Elizabeth Mateos.
All right, defense?
May I proceed, Your Honor?
Yes.
Ms. Mateos, do you know Raymond Ruiz Jr.?
Yes, I do.
Do you, how are you related to him?
He is my boyfriend.
You know, he's remanded without bond in this case.
Yes.
You're asking the court to set a bond.
Yeah.
Okay, and where do you work?
Provider for phones.
Okay, and how much do you make a week? Okay, and you have expenses yourself?
Yes.
Okay, and how much do you make, how much do you have in expenses a week? Yeah, you're almost breaking even.
Yes.
Let me ask you, you're asking the court to set a reasonable bond in this case.
Yes.
How would you're asking also the court to set a bond at least 40 to 80,000. Okay, how much of a bond can you afford in this case?
I don't know.
But you're still, will be trying to
Yes,
bond them out into the bond set
yes.
and no further questions down.
All right, any questions?
Yes, Your Honor.
Dave?
Is it Ms. Mateos?
Yes.
Ma'am, so I guess you're the victim in an incident from October of last year, right? Or you're the alleged victim from that case?
Yes,
You understand? I'm sorry?
I'm sorry. There was an affidavit that I defended.
Yes. So you filed an affidavit of non-prosecution,
Right.
basically saying that it didn't happen, right?
No, yes.
Okay. But you understand that case was filed, that you're listed as the victim for the case.
Yes,
from
I just
October.
found that out.
So this lady right over here, she's got to take down everything that's being said. So if I'm asking a question, if you can just let me finish asking the question, and I'll try to do the same for you. Now you understand that the case we're here for today, that they're asking for a bond to be set for, that's not the same case that you were listed as a victim for.
That's right.
Okay. Are you aware of the other cases that Mr. Ruiz is charged with?
Yes, yes.
Okay. What do you think he's charged with?
Assault with a deadly weapon. I believe.
I'm so sorry. Can you make sure you speak up so I can hear?
I think it's assault with a deadly weapon.
Oh, and that's the one that we're here for today,
Yes.
for the bond hearing. Are you aware that he's actually been charged with those kinds of cases before?
Excuse me. I'm sorry.
Are you aware that he's been charged with those kinds of cases before?
Yes.
Did he tell you about those?
Yes.
And he's actually been convicted and gone to prison for them before, right?
I don't know.
Now, on the day that this happened, I guess you talked with a constable, right? Was it Deputy Sanchez? Does that sound familiar?
I don't know what the names.
Okay, but you talked to some police officers.
It was at a convenience store.
Okay, and you talked to the officer on that day?
Yes.
And you understand the importance of telling the truth to the police,
Yes.
right? Do you have any children?
Yes, it is.
What children do you have?
I have a 12-year-old.
And are you concerned for your 12? It's a 12-year-old son, right?
Yes. No.
Okay.
They have a real good relationship.
I'm sorry, I couldn't understand what you were saying, that last part. What did you say?
They have a real good relationship. My son and Mr. Rose.
I mean, that's not really what you convey to the officers, right?
When I read the report, it doesn't sound like anything that I said that day.
Okay.
I mean, none of it adds up the same thing that happened that day.
Okay. So when you said Mr. Ruiz had threatened to kill you and your son, that is not true.
No.
And
All right, and I'm sorry, just one moment. If this witness is going to deny what she's told the police, she'll probably need to have an attorney appointed to represent her. So is that your intent, to deny what's in the police report?
Yes.
All right. You want to ask another question of this witness?
we'll pass the question.
All right, any other questions?
No further questions, Your Honor.
All right, may I ask one question? Is there any objection? How long have you known Mr. Ruiz?
I've known maybe about 10 years.
All right. And you say that you are a home health care provider?
Yes.
And are these persons that you take care of in your home?
No,
Or you go out to visit them?
Yes. Yes.
And are there any other children in your care other than this 12-year-old?
Yeah.
Do you have children that you babysit other than the 12-year-old?
No.
All right. Thank you so much for coming in. All right. Any other witnesses?
Oh, Your Honor.
All right. Mr. Ruiz. All right. The court will hear argument. Defense, any other argument?
Because the only thing is that we ask the court to consider putting a bond. Usually when somebody comes in, usually the bond is doubled. That's what we're asking the court, so case 3,000, $180,000.
All right. Request for bond is
And just like that, the bond is denied. This is a huge blow for the defense. The judge is listing off a laundry list of new charges, assaulting peace officers in retaliation, all while he was already out on bond. This is why judges get tough. If you can't follow the rules while waiting for trial, they aren't going to give you a second chance to break them. But the real drama is the no contact order. The judge is literally telling him, she doesn't love you anymore. Ouch.
Tonight, I'll see y'all back on April 3rd for jury trial.
Thank you, David.
right, thank you.
We don't have a bond sit at all?
No.
Not any bond.
And we're off the record, but Mr. Ruiz, while you're on bond, and I don't take any of these cases as true, but while you were on bond for aggravated assault with a deadly weapon, you then are charged with assault of a peace officer, another assault with a peace officer, and retaliation. And also a retaliation. So there will be no bond set in this case.
Thank you, Judge, maybe excuse.
Yes. Thank you.
You stand right here.
No, yes, you can stand there.
That's right. I was trying to figure it out. Your Honor, my client Raymond Reeves, he's got 6 pending felony cases and 3 misdemeanor cases. There has been an offer tendered to him by the state, and there's been an second offer tendered by the state, which is lower than the first offer. However, my client wants to hire another attorney and wants more time so he can figure this out.
Mr. Ruiz, if you come down, please. I see the file on Mr. Ruiz. Hello, Mr. Ruiz. All right, Mr. Ruiz. This is an old case, and this case is going to trial. If you wish to hire an attorney, you're more than welcome to hire an attorney. But that attorney you hire, you need to let them know that you're going to trial tomorrow and they need to be ready for trial. Do you understand? So this case is going to trial tomorrow. Yes.
It's the first time I've ever met this attorney, and I want to see how I can go to trial. And it's the first time I've ever met him. I've never met him, and the first time I've ever seen him, I've never seen this guy too. Never, because it's the first time I've ever seen him, and first time I've ever seen this client. It's the first time I've ever talked to him about this case. And go to trial so soon, so quick. This is the first time I've ever met this.
Mr. Ortho was hired on one case,
Mhm.
the older case, and Mr. Davidson was the one on the night cases. So
Now, Spania,
Yes.
Your Honor, I was called by another attorney, Thomas Moore, to go to federal court. In federal court, I had to speak to the federal judge, and at that time, this man was present. We did meet, we did talk. We did not talk about these cases. We did not talk about.
No, I understand, Mr. Davidson, but I want everybody to understand me clearly. Everyone hear me clearly. This is come back tomorrow for jury trial. And since the state USED council has made a new offer, you will need to make your decision on whether or not you're accepting the state's offer by tomorrow. If you choose, because they're going to bring you back here tomorrow at 9, the jury is going to be up here sitting out here at 9:30. If you choose not to accept the state's offer, your plea deadline date will have expired. And at that point, you can either plead open to the court, and the court will not accept any plea bargain agreements without good cause. So we will see you tomorrow. Or if you would like to continue to sit in the box to confer with your attorney, you may do so, but we will see you tomorrow for jury trial.
May I ask a question?
Yes.
If he comes back tomorrow morning, is the state's offer still on the table?
Yes.
Okay,
According to the judge.
Yes.
thank you.
Yes. It's on. So, Mr. Ruiz, it appears that the state is not going to keep their offer open tomorrow. And I have no control over that because the plea negotiations are between the state and your counsel. And I either accept or reject the plea. So it appears, and your counsel will be able to tell you, state, are you keeping this offer on the table for him tomorrow?
Day to day.
Right. So they're saying today is your day. Who's here on Sergio Salinas? And each cause you're charged with the offense of assault on a peace officer, judge bodily injury as a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, just ask the court to accept the plea bargain agreement that we have with the state.
This is William Davidson, Your Honor, and I asked the court to go along with the plea, but I also wanted to put on the record that last night I e-filed 3 motions for continuances on my cases. I'm asking the court to disregard these in lieu of this plea. I was going to argue to the court certain criteria my client had brought up, but this plea makes all that moot, and my client wants to go ahead with this plea. And so I'm just asking the court to agree with the.
All right. And cause number 2023 CR 0293, court will follow your agreement, sentence you to 6 years in the prison, give you credit for any time served. This is run concurrent with 2023 CR 0293. County Court, taking consideration County Court cause number 6845525 695189700 500 2023 CR 0294. And just one moment. 2023 CR 0295. The court is going to sentence you to 6 years in the prison, give you credit for any time served. This will run concurrent with 2023 CR 0293. Taking consideration County Court cause number 6894525 6951889 2023 CR 0294. County Court cause number 700500. And there's to be no contact with Elizabeth Mateos. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Yeah, I just wanted to put one thing on the record to make sure that it's clear that I talked to my client about this. I met him in federal court. He was released from federal court to deal with this case. My understanding, once he does the state time, he's got to go back to the federal prison. I just wanted to put that on the record.
Okay.
Nothing else, Your Honor.
All right, thank you. And each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
And each cause number, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And in each cause number, because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or an ammunition is, you'll need to speak to an attorney. Do you understand? All right, you can go off the record. How old are you?
43.
All right, you're going to have to make some changes in your ways. Otherwise, you're going to find yourself in and out of prison. And that's where the majority of your life will be spent. You're going to look up, your life is going to be over. If you continue the way you are, you're going to end up in federal custody, end up in state custody, and end up in somebody's jail. You understand?
Mm-hmm.
Now, I am serious. When I ordered that you to have no contact with Elizabeth, you are not to have contact with her. Do you understand?
Yes, ma'am.
She does not want you anymore. She does not love you anymore. Well, maybe she still loves you, but you all should not be together. But that's not a good pairing. Do you understand?
Yes, ma'am.
So you are to have no contact with her. All right?
Yes, ma'am.
All right. Good luck to you.
Your Honor, I'm sorry. Can I just add one thing? Can you
Sure.
come back, please? I'm sorry.
Excuse me. Mr. Davidson wants to add one thing. Yes.
Yes. Your Honor, I understand that you made a no contact order with one of the alleged victims. However, on the case dismissed, there is another alleged victim. I'm assuming the court has no intent to issue a no contact order in that.
Who are the complainants in the other case?
I think that's your case. I'm not.
That case was dismissed, Your Honor.
All right. This is the aggravated assault.
It's case 7154
All right. Just one moment.
22.
We're on the record. There's also to be no contact with Lisa Gonzalez. And that's Lisa, and that's Gonzalez with an S. And there is also to be no contact with I've already stated Elizabeth Mateos. So state if you can please let the complainants know in those cases that the defendant is not to have any contact with them. And they have the ability to not accept phone calls from the jail. So if you make contact with them, there's going to be issues. There's going to be issues with your parole. There's going to be issues with whatever is happening in federal court. Do you understand? All right. Thank you.
Thank you.
Thank you, counsel. Who she brought with her in the background just said it was June and not July.
Yeah, I'm sorry. 6/26 was the date my grandfather passed, but we didn't have the funeral until the 19th of
July.
Yes, because Fort Sam was backed up.
And to be specific, Judge, my question to her was not the use of drugs. My question to her was very specific. It was the use of marijuana. That was what I was under the impression of. I still think that she has exhibited full candor with the court. She has not dodged the court's questions. She hasn't gone down the rabbit trail for 15 minutes trying to suggest other excuses why.
I asked your client if she was going to be positive for drugs.
I understand.
Marijuana is a drug, and she said no.
Right, I understand that, Judge. But at the same time, I know the drug stays in your system for more than 3 days or more than 30 days. And so she may have not been aware of that, Judge. But the fact is, after I told her about that, she admitted to you that she would test positive.
And then, so what I have before me is a person who's saying that she's taking care of her aunt. And didn't she say she was taking care of a child as well?
It's not her child.
I hear that improperly?
It's Ms. Rubio, is it not true you are taking care of your 8-year-old niece and your 7-year-old nephew, or you're helping to be a caregiver for them? Can you explain to the court what role are you playing with them?
Well, I am the sole provider now. My grandfather left everything to me, so I have to now, take care of the house inside and out, and the kids. And like I said, I'm sorry, Judge. I wasn't really realizing how long they stay in your system, but I really am trying. I haven't picked up any new cases. I have been working at Educare since early November of 2020. Steady employment. I'm doing the best that I can, and I will continue to. If you could just please, I just don't want this hanging over my head anymore.
Well, I don't understand why she is being allowed to take care of a 7-year-old and 8-year-old, and she's using marijuana, Xanax, and Vicodin. Somebody explain that to me. How is that appropriate? How does a 7-year-old and an 8-year-old does not deserve somebody who's not using marijuana, Vicodin, and Xanax?
This just took a dark turn. We went from a sentencing hearing to a potential CPS referral. The defendant admitted to using marijuana, Xanax, and Vicodin while being the sole provider for a 7- and 8-year-old. Watch the judge's face. She's not just a legal arbiter anymore. She's worried about those kids. When a judge asked the entire courtroom to raise their hand if they'd let this person babysit and nobody moves, that is a deafening silence.
I mean, where is this going? Is there anyone on this screen today who would want this defendant to babysit their child knowing what they now know? Raise your hand if somebody would want this person. All right, then somebody call CPS. Does anybody want someone who's using marijuana, Vicodin, and Xanax to be in charge of a 7-year-old and an 8-year-old? I find that very concerning because she's saying what she says. It's neither, honestly, it's neither here nor there. If I give her 60 days, judgment satisfied, and she walks out of this courtroom, let me just tell you what happens. One, she's no longer on probation. She can use as much Vicodin, Xanax, and marijuana as she wants. And she's telling me that she's in charge of a 6-year-old, 7-year-old. And then I'm assuming I'm supposed to feel sympathetic, which I do. I empathize and I feel sympathy for people who've lost their loved ones. But she's lost someone in her life, which is devastating. So now I have someone before me who has 2 children that she's the sole caretaker of. That's what she said. She's the sole provider. I have somebody who's using drugs. Her relative died in June. So we do know, based upon her testimony, that she actually used drugs at least 3 days ago. I don't know if that happened in the home where the children are or not.
No, ma'am.
All I know is she's the sole provider for a 7-year-old, 8-year-old using drugs. And I'm supposed to allow her to go out in the world free from any type of supervision to take care of a 7-year-old and an 8-year-old where she's using drugs.
Your Honor, at this juncture, I'd like to do is call her sister, which she's sitting in the back as a witness to Ms. Rubello's ability to be the caregiver and the circumstances regarding her becoming the caregiver of the niece and nephew.
Sure. Have the sister come up, please.
We're ending on a cliffhanger as the sister prepares to testify. This case highlights the messy intersection of grief, addiction, and childcare. The defendant is pleading for freedom, but the judge is looking at a toxicology report and 2 vulnerable children. Was the judge being too harsh, or is this the wake-up call this family needs? Thanks for watching this breakdown. Make sure to hit that subscribe button for more Courtroom reality.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. State your name for the record, please.
My name is Sasha Beckett.
All right, and I'm going to need you to speak up.
My name is Sasha Beckett.
Spell your last name, please.
It is Beckett.
And spell your first name.
It is Sasha.
All right, defense.
Hey, Ms. Beckett, you've heard the testimony of Ms. Rubello and you've heard the concerns of Judge Boyd here today, have you?
Yes, I have.
Okay. And then so what is your observation? She mentioned, that is, Ms. Rubello mentioned that she had taken Vicodin and I believe it was Xanax. And do you know whether she had any prescriptions into those drugs previously?
Previously, yes, she has. My sister has been in numerous car accidents. She does have herniated disc in the lower and the upper, the lower lumbar, as well as the upper. Now, she does not have medical insurance. I was trying to get her on mine, but, you know, I'm not able to, not in the state of California, no. Now she hasn't worked long enough for her medical benefits to take effect. But my sister's not an addict. Is she in pain? Yes. And I see it like the whole time I've been here. I mean, like cringing in her bed from the pain.
Well, Ms. Beckett, can you tell the court, in terms of whether or not the passing of the grandfather has been a stressful experience for the family?
It has been beyond stressful. More so to Valencia because our grandfather raised Valencia. Like that is, I had a dad. And our mom was around, but she wasn't around. And my grandfather has been Valencia's mom and dad all her life. And she has taken care of him, for 5 years. And he has other kids. And then he has some grandkids, but no one
Yeah, so Miss
there for him like Valencia was.
Miss Beckett, let me interrupt you just for a second. Could you tell the court, how did your grandfather end up with the 8-year-old and 7-year-old niece and nephew?
It was due to the passing of our oldest brother.
And how long had he taken care of them?
Since 2 and 3. And he had just finished having open heart surgery, 2 of them back to back, because the hospital messed up on the first one, and they had to go back in and redo it again. And Valencia was the only person there, and it's not right, because we as a family should have came together at that time, but for different circumstances.
Right. So Miss Beckett,
able to be there.
Miss Beckett, where do you reside?
I reside in California, post-domestic.
Okay, so are you here just to visit for the funeral?
Yes, and I'm just trying to, kind of help Valencia get everything into perspective. But yes, my life is in California.
Okay.
Valencia is really just here by herself. We have an elderly aunt that also stays in my grandfather's home that Valencia also cares for.
So Miss Beckett, prior to your grandfather passing, the household consisted of your grandfather. I'm sorry, what was his name?
His name was Lawrence Rebello.
So the household consisted of Lawrence Rebello, correct?
Yes.
And then the Valencia Rebello, that's her dad, correct?
No, that's my grandfather.
That's grandfather. I'm sorry, her grandfather.
Mm-hmm.
And what are the names of the two children?
It is Serena and Dominic.
And so the household consisted of the 4 of them. Is that correct?
Yes.
So
I'm sorry, it's 5 because my elderly aunt is there.
Okay. So is your elderly aunt in the household now?
She is in the household now.
And how old is she?
66.
And so what role did she play being a caregiver for Serena and Dominic?
She doesn't. She's just there. She's a very, very, very selfish, very mean lady.
Okay, well, I just want to know not what her personality is. I'm just asking.
She doesn't care for them.
Yeah. And do you have personal knowledge that she has never taken or participated in the caretaking of Serena and Dominic?
From my knowledge, no.
And so do you think that Serena, this is not about Serena and Dominic, but whether the judge should allow Valencia to have a judgment satisfied in this case because of the nature of her drug use. And so what you're saying is that she had prior prescriptions for Vicodin for her back and for Xanax, correct?
Yes, and then the Vicodin was like, they even have to up her for her pain medication, as well as I think it was muscle relaxers that they had given her.
Okay, but so the use of the medications is related to physical injuries and stress.
Yes.
Okay. And so to your point, other than those three things we talked about, the marijuana, the Vicodin, and the Xanax, can you tell the court whether you have ever seen Miss Rebello use any other drugs or consume any of the drugs?
No, I have not. And not since my time being down here.
Okay. And how long have you known Miss Rebello?
All my life.
No further questions for this witness, Your Honor.
All right, any questions, State?
Just a few, Judge. Hi, Ms. Beckett.
Hello.
So I understand you to be saying that Mr. Rebello is the only person that is actively taking care of Serena and Dominic. Is that right?
Yes.
And I do empathize with Ms. Rebello and her pain, but when the pain gets to be unbearable, who else is there to watch these children when she has to deal with the pain in whichever way she chooses to do so?
You know what? There's no one. Like I said, I'm down here now, helping her put things into perspective and into place. But by far is Valencia an irresponsible caregiver. And I mean, I wish I was able to bring the kids in here to, to speak on her behalf, because she takes great care of them.
I understand, Ms. Beckett. My question is, if Ms. Rebello is under the influence of some substance to deal with this pain, who else is there to watch these children?
It would probably be, a family friend, or, myself as of right now.
But you live in California?
Yes. But, I would have to do what I have to do, for them as well as for Valencia.
I understand. Thank you. Pass the witness, Judge.
All right, thank you.
Thank you.
You're welcome. All right, this is what the court is going to do. The court has denied the motion. The court is going to alter and amend conditions to include random UAs, parenting classes, and there's to be no employment as a home healthcare provider or employment with minor children. Is there anything else from either side?
I think from the state, Judge.
I'm sorry, Judge, can you repeat that so I can get this down?
Yeah, Mark. I'm denying the motion. I'm altering and amending conditions to include random UAs, parenting classes, no employment as a home healthcare provider or with minor children. And Rebecca, I'm going to want a UA today so she can be tested for levels.
Okay, so parenting classes and UAs.
Yes.
Testing today. And motion.
And Ms. Robledo, those levels need to start dropping. Do you understand? So there's to be no more drug use. Do you understand?
Yes, ma'am.
Okay, so then she will be continued on her, because I think she was on 2 years.
Yes. No, she's on regular probation.
Regular probation, I'm sorry.
Defense ready.
State's ready.
Yes, Judge.
All right. State, this is the motion that you filed with the court. So you are first to go. Do you have any witnesses? State.
Witnesses, no, Judge.
All right. Defense, do you have any witnesses?
Unless Mr. Blanco wants to address the court, I do not, Judge.
All right. Mr. Blanco, would you like to address the court?
Yes, ma'am.
All right. If you could raise your hand, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. Could you state your name for the record, please?
Richard Blanco.
Court already?
With the GPS, yes, and I just felt like I was taken away from it when I came to court. I thought I was doing everything that I was supposed to do, and when I was on GPS and everything was rolling right, and that's why I'm really not understanding why I was incarcerated.
Okay, so let's talk a little bit about that. Doing everything you're supposed to. Tell me what you think you're supposed to be doing on probation.
As far as staying away from the drugs, as far as staying away from people I'm not supposed to be around. I finally got my ID. I haven't had my ID since I was 18 years old. I'm 29 right now.
Are you supposed to show up to probation? Is that part of probation?
Yes.
That's
And
part of the. Hold on.
Oh, I'm sorry.
You'd agree with me that's part of the chance or chances that the judge has given you?
Yes. And I was doing everything I was supposed to. I did do the Zoom. The only thing is
Well, hold on now. I want to ask you some questions about doing everything that you were supposed to, okay? Doing the right thing. You paid attention when we were in court last week, right?
Yes, sir.
This is important to you. It affects your life. So you are paying attention to every bit of it, right?
Yes.
Okay. So you heard the judge find it true that you were not showing up to your probation in 2019.
See, but the thing is, that wasn't even my turn. That wasn't.
My question is, you heard the judge find it true that you were not showing up to probation in 2019.
Yes, but that wasn't true though, because that was.
You heard. Hold on.
Okay, so here's the thing, everyone. One, Brenda can only take one person down at one time. So, ask a question. Mr. Blanco, answer the question.
Yes, ma'am.
But I can't have everybody talking over each other because guess what? When I look at the screen for what Brenda's typing down, what I can read, it's very difficult for her when two people are talking at once. All right, next question.
Yes. Okay. You heard the judge find it true that you did not show up to your probation in 2020.
Yes.
Okay. You heard the judge find it true that in September of 2020, you had an ounce of meth and a deadly weapon in the car with you. You heard the judge find these things true.
Yes.
Okay. And somebody who is doing everything they're supposed to on probation, we at least agree, is supposed to show up and not get caught with doping guns. We can agree on that, right?
Yes.
All right. Now, I want to talk to you a little bit more about chances. When you got put on probation in both of these cases, they happened on different days. Back in, was it 2018? The UUMV and the drug case that you're on probation for, they're from two separate days, right?
Yes.
Okay. And back in 2018, those weren't the only cases you caught, were they?
I'm really not sure.
Okay. Did you have a tampering with evidence in October of 2018 that was dismissed with these pleas?
I don't know.
Okay. Did you have an escape from felony custody or correctional facility August of 2018 that was a part of these pleas?
No, not that I know of.
Okay. Would it surprise you that I'm reading your record and you did?
No. I mean,
Okay.
it's surprising me, yeah. But I don't recall any of that.
Okay. Did you have some other drug charges in 2018 that got dismissed as a part of this plea deal?
No.
No, you didn't? Okay. Well, let me ask you this. If you did, and if those were all dismissed to put you on this felony probation, would you say that was a pretty big chance you were given back in 2018?
Well, if they were dismissed, that means it wasn't that I didn't do any of that.
No, that's not what it means. But my question is, if they were closed out, if they were dismissed, and you can think whatever you want about that, but if they were dismissed because of the pleas, because of the probation, would you agree with me that's a pretty big chance?
Yeah.
6 felonies gets turned into 2 felonies for probation. That's a pretty big chance, isn't it?
Yeah, but if they're dismissed, I didn't do any of that.
Okay. But we agree that's a big chance.
Not if I didn't do it.
Okay. All right. We could disagree on that. And that if you're on that chance, doing the right thing is showing up to probation and staying out of trouble. We agreed on that, right?
Yeah.
All right. Judge, I pass the witness.
Defense?
I don't have any other questions, Judge.
All right, defense, call your next witness.
Judge, I don't have any other witnesses, just argument on disposition.
All right, state, any witnesses?
No, Judge, this argument.
All right, state, you may proceed.
Yeah, Judge. Well, we stand on our evidence that was both judicially noticed by the court as well as the testimony and evidence proffered forth in the hearing. We would gently remind the court that these are straight probations and that the underlyings should be automatic. Mr. Blanco bargained for those underlyings, and we would really say to the court, he can now get the benefit of his bargain. I think he's here asking for the 8th or 9th chance, not the first. I think it's a little bit inappropriate. He brings small children to court to see this. But that being said, the state is absolutely shocked that he thinks he was out in the world doing what he was supposed to and doing well. The court has seen that Mr. Blanco was out dealing drugs, that he had a deadly weapon on the court's probation. This is a very serious thing. This is the type of thing that the court doesn't want showing up in the news, in the media, with probationers who are quote unquote doing the right thing. Mr. Blanco got 4 felonies TIC in the original deal between several offense states, set a tremendous amount of leeway for the court. I detailed the chronology that he had an FTA in May of 19, a REWAB in November of 19, another FTA in March of 20, another REWAB in May of 20, and then finally a surety to surrender in September of 2020. The court found true 3 multiple date number 5s, an ounce of meth, a new deadly weapon, new bond violation. Down the road, time will tell what we do with Mr. Blanco's new number 1s, but what we are asking for here today is that you revoke Mr. Blanco and you give him the benefit of his bargain. He bargained for 2 and he bargained for 5. He did not comply with the terms of the court's probation. That's exactly what he did, and we now ask that he gets the benefit of his bargain.
All right, defense.
Judge,
And just for the record, Mr. Blanco's underlined in 2019 CR 0192 is 2 years, and his underlining in 2019 CR 0193 is 5 years. And defense, I'll hear from you.
Judge, I did discuss both of those with Richard and informed him I did not represent him at those pleas and reminded him that that was basically his promise to the court, that if he violated the terms of his probation, that is what he should and could expect. Yeah, and I have no misgivings about what I believe the court is likely going to do, and I'm certainly not going to suggest that it would not be merited. Richard has asked me to ask the court to consider allowing him to go into a treatment such as Safe P. And I can tell you this, I'm not saying that the court should not consider a prison sentence. Richard absolutely could benefit from Safe P. There's no doubt in my mind. In talking to him and the issues that confront him, he does have probably substance abuse issues. I'm sure there are things in his mental capacity that certainly could use a lot of tightening up. And basically, I can tell the court that Richard needs a lot of help learning how basically to conflict resolve and make better choices. When he was telling you about his business in the last 6 months, it's unfortunate that it required a GPS and the specter of prison to get him to walk the line. But he's actually, what he was trying to tell the court was he's been doing very, very well, which he has. And I understand the court looks at that with a bit of a jaded eye because of the situation that he's in, and had hoped that he had done all this when he was first put on probation, as would I, as would Richard. So you only have that other option, Judge. I would ask you to consider it. He's on a good path now, but I understand all the other information that the other side has given you. So we, of course, will defer to you on your decision.
Okay. All right. I want it to be noted for the record that the court, in making its decision, does not consider what the media is going to say, what the public is going to say. The court looks at each case on a case-by-case basis, and the court seeks to make what I hope is always a just decision. And that's what I will do in this case. Mr. Blanco, I've heard all of the testimony that you've given. I remember all the evidence that was received by the court and the testimony that was given by the court. Mr. Blanco, I'm well aware that you're saying that you have drug issues. I understand that. But what I'm going to do in each of these cases, in cause number 2019 CR 0192, I'm going to sentence you to a $1,500 fine, 2 years in the state jail facility, give you credit for any time served. This will run concurrent with 2019 CR 0193. Time and money will run concurrent. Mr. Blanco, your attorney has said that you have drug issues. Would you like to be considered for the therapeutic community?
I don't know what that is.
All right. Well, the therapeutic community is designed to help you with any type of addictions you may have. I have no authority to force them to place you in the therapeutic community. But if they decide to place you in the therapeutic community, you, well, it does not increase the time of your sentence. You understand? But it's to help you with any other drug issues you have. So would you like for me to request that they place you in the therapeutic community?
Yeah, that's fine.
All right. And again, if you don't ask for it, you'll have to ask for it as well. If you do not ask for it, they will not even consider it. Do you understand?
Yes, ma'am.
All right, then in cause number 2019 CR 0193, the court will sentence you to a $1,500 fine, 5 years in the prison, give you credit for any time served. This will run concurrent with 2019 CR 0192, and I'll request that you be placed in the therapeutic community. Time and money will run concurrent. In each of these cause numbers, Mr. Blanco, it's my understanding that you did not want to sign the trial court certification of defendant's rights to appeal. So I have been given a copy of both, and I will write here that you refuse to sign. And Mr. Toshi, I'll note for the record that you are by video, and it's impossible for us to have you sign one, send it to me without, and somehow avoiding your client's signature. The system doesn't allow us to do that. So, Mr. Blanco, and cause number 2019 CR 0192, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion. And in cause number 2019 CR 0193, you do have a limited right to appeal, and that is as it relates to the allegations in the motion. Do you understand?
Yes, ma'am.
All right, Mr. Blanco, we can go off the record. Mr. Blanco, I understand your position. I understand you may be angry with the court right now and feel like the world has done you wrong, but you have young children and you need to make a decision whether or not you are going to straighten up your life. Do you understand? Now, you can go to prison. When you go to prison, you can either internalize and grow, or you can come back out. And if you come back out and you continue doing the same thing, you're going to look up, your children are going to be adults, and you are not going to have a significant role in their life. So it's completely up to you whether or not you want to change your life. When I place people on probation, I'm hoping that they will be successful, because I take no joy in sending people out of prison or to prison. The reason why I placed you on probation was because I wanted to give you a chance, and I thought you could be successful. And the court was aware of your drug problem. That's why as one of the conditions, I placed you in intensive outpatient treatment. I was aware that you had young children. That's why I placed you in parenting classes. And so we're here where we are now. But I wish you luck. Okay, Mr. Blanco?
Yeah.
All right, good luck to you.
Judge,
Yes.
I am still attorney of record. He still has 2 indicted cases.
Yes.
Would the court at this juncture, given the procedural history I've had with Mr. Blanco, consider allowing me to withdraw from those cases? My understanding is the state still intends to proceed on them, and I could file a formal motion as well. I just wanted to see if the court would be comfortable allowing me to withdraw.
All right, let's do this. So my understanding from our last hearing that he was hiring Daniel De La Garza.
Yes, ma'am. And I communicated with Mr. De La Garza. I've spoken to the family as well. I do not foresee that happening in the immediate future on the family's end.
All right,
So-
this is what we'll do. Norma, on Mr. Blanco.
Yes, ma'am.
Can you recall this for the week of March 22nd?
Okay.
And I'm setting it at that time, Mr. Toshi, because that's when I will be back.
Okay.
And Norma, have Mr. Daniel De La Garza appear so we can see if he's going to be his new attorney. If not, Mr. Toshi, of course, I'll consider your motion to withdraw. And based upon what has been discussed by yourself and by the state, that will end up being granted. But I don't want Mr. Blanco to be at a point where he doesn't have an attorney with pending cases.
Understood.
And where is Mr. Rowley?
And Judge, his name is incorrect. It's actually Riley Adams.
Oh, Ray Adams?
Riley Adams.
Riley
He just
Adams.
mixed it up.
All right. Hello, Mr. Adams. All right, so your attorney's filed a motion to withdraw?
Yes, Judge.
All right. All right, so they're saying they're having problems communicating with you. All right, so, oh, no gum chewing. That's okay. It happens. Don't swallow it, though. Our parents would always say it would mess up your intestines. All right, so let me explain something to you about communication with attorneys. I've been a defense attorney. I've been a prosecutor. Sometimes attorneys will tell us things. We don't like what they say. So then we say, it's your fault. This profession has to be the only profession where if somebody's in trouble, they blame their attorney. And I understand that. But usually when people have a medical issue, if they have a heart problem, they don't start blaming the doctor. It's your fault. I have a heart problem. Their whole thing is, what can I do so we can resolve this issue? But with attorneys, when you have a case, sometimes you're, why hasn't my case been dismissed? Why am I not in jury trial? Why hasn't this happened? So what I can tell you, if the issue with your attorney is, hey, why am I not in jury trial? It's because we have cases that are set before yours. If your issue with your attorney is like, you haven't got my case dismissed, attorney can't force the state to dismiss your case. If they want to dismiss it, they'll file a motion to dismiss, and then it'll be up to me to sign it. And if I don't want to sign it, I don't have to sign it. So if that's the issue, this motion to withdraw is not going to be granted because you need to communicate with your attorney. And what I can tell you, if you're not speaking to your attorney, you know what's going to end up happening? You're going to end up going to a jury trial with an attorney that you have never spoken to, and that's going to be your fault. How old are you? All right, you're 50. So it's not like you're 3 and people can't communicate with you. So she's saying she has a problem communicate with you. Step back, communicate with your attorney. You understand? All right, thank you. All right. Sure.
Hey, Judge, to finish short.
Yes.
I know that we've been waiting a long time for him.
Yes.
We have.
Okay.
However, Pat Hancock wasn't given notice and he's out of county. He's asking for it to come back Monday.
Okay.
And the reason he wasn't given notice, Judge.
And I'm fine with that even.
They between Mr. Hancock's.
Okay.
He wasn't on the docket, so.
All right, so y'all want him here on Monday?
I'm fine with that.
Okay.
And we should be able to work.
Oh, yeah, sure, Monday.
So I'll just.
Sure. All right. You've been on this planet for 50 years, right? You need to speak up so I can hear. All right, let me explain something to you. People always say to the bold, you know, you get things because you're being bold. When I was a defense attorney, I would have male clients sometimes that would hit on me, right? And you know what I would tell my client as I'm seeing them at the jail? I would be like, you would be such a good catch. If only you didn't have this SID number and was charged with murder, I would consider. So you need to respect your attorney. Your attorney knows all of your criminal history. Normally, women do not want to hang their star to somebody with criminal history. And when you are in a professional setting, you need to speak to that person professionally because that person holds your life in their hands in a way. Like maybe they don't want to represent you very well. Maybe it's, hey, this guy's hitting on me, he's all creepy. Maybe I should just let him go to jail. So the next attorney you get, speak to them professionally. There's none of this, hey, sexy, hey, baby, because they're not interested in you. Do you understand?
Yes, ma'am.
So I'm going to allow your attorney to withdraw. Have a seat. You're going to get appointed to a male attorney. Have a seat. Thank you.
Thank you, Judge.